Good morning and welcome to today's webinar, What Families Need to Know About Planning for a Loved One with Special Needs, presented by Elville and Associates, Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome, we're glad you're here. You as the attendee are in listen-only mode. However, you do have a voice. When you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout the presentation to address them. You did receive the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive the presentation, it is available in the section marked Handouts in the panel on your screen. For CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending today. For attendance records requirements, please email me your board ID number, and for CFPs only, I need the last 4 digits of your Social Security number as well, as soon as possible, so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out the simple survey to offer us your feedback about the presentation. It's also an ideal time to request a consultation with Steve for planning needs your family and you may have, and we always look forward to being a resource for you now and in the future here at Elville and Associates. So briefly, I want to offer an overview about our firm and give you a little bit of background about Steve. And I know we have a lot of new people here on the presentation today. So again, welcome. We're really glad that you're here and how you found us through various different channels. So I'm gonna pull up a little bit of information that I created to give you an idea of our firm here. So we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. Whoops, got ahead of myself there a little bit. Many different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection, along with other areas. We have 7 attorneys, 12 staff members, and 5 locations. Today we're coming to you live from the Columbia Gateway location, which is our primary location. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. And again, we offer a lot of education here at the firm. It's one of our foundations. We do that through our planning processes with our clients. We offer well over 100 educational webinars and workshops here and in the communities we serve each year. And also by way of our accredited client care program, we're only one of 2 firms in Maryland to have a client care program, or CCP, as we like to call it, accredited by the Client Care Academy in Boston. And many of our clients take advantage of it for the many benefits that come with it. We also work with the ideals of client education, collaboration, and compassion in mind with every client, every time, every day. A little bit about Steve. I can find it here. So Steve has been working as an attorney for over 20 years now and has been specializing in the areas of elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection, a member of numerous professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He brings a unique mindset to the conference room. He works to bring peace of mind to clients by creating solutions to our clients' needs through counseling, client education, and the use of leading-edge legal technical knowledge. Last year's chair of the Elder Law and Disability Rights Section Council of the Maryland State Bar Association, presenting countless times each year through webinars, workshops for businesses, conferences, and also was named to the Maryland Super Lawyers list for a 6th time in 2021. So congratulations to Steve for that very distinct honor. So we're going to get started here. I do want to start off with a brief poll to get an idea of what's brought you here today. And the poll is, to get to know our audience, please tell us what has brought you to today's webinar. So I'm going to go ahead and launch that poll right now and just select the answer that best suits you. And the choices are, I need to set up planning for a loved one with special needs. Second, I have planning in place, but it needs to be revisited. Third, I'm a financial advisor here to learn to benefit my clients. Or last, I'm an interested family member here to gather information. So if you will, choose the option that best suits you. And it looks like everybody has been very quick to answer here. So with most everybody having chosen already, we have 35% saying I need to set up planning for a loved one with special needs, 6% saying I have planning in place, but it needs to be revisited, 24% say I'm a financial advisor here to learn to benefit my clients. Welcome to all of our advisors out there. And lastly, 35% say I'm an interested family member here to gather information. Okay. Thanks for participating. I'm going to close that out. Steve, I'm going to go ahead and turn the reins over to you. I'm going to make you a presenter. You should see the button pop up on your screen there.
Very good. Thank you for that. All right. And I'm going to go, hopefully be able to manipulate the slides. I think I can, Jeff. And I'm going to go play from start on the slideshow. And I think we're good. Well, thank you, Jeff, and good morning, everyone. And this is Steve Elville from Elville and Associates, large conference room here in Columbia, Maryland. And I thank you for taking time out of your morning this morning on a busy middle of the week here on a Wednesday to learn more about special needs planning and planning for a loved one with special needs. It's my great privilege to be here with you today. This is one of the most dear seminars, if not the most dear seminar, a seminar that's dear and close to my heart about our privilege to be involved in the special needs planning community and to share information with you. And I appreciate your varied interests, those of you who are interested in planning and those that are interested in updating planning and interested family members and financial advisors and CPAs. Thank you for your interest in spending time with me this morning. I just want to say our mission is to educate in this workshop. I'm here with our new associate, Shannon Werbeck, who is attending today here in the conference room. We're socially distanced, so that's why I have my mask off to give this presentation. I also want to thank Jeff, without whom I could not do these workshops. Jeff does a wonderful job, and I'm going to talk in just a second about how you can ask questions during this workshop. Jeff is extremely committed to the special needs community, as is his family. And Jeff, thank you for everything you do to help me put on these workshops. So Jeff is our moderator. He's a pro, and we're going to talk at various times. I'm going to stop the presentation at various times, and I'm going to ask if you have any questions, and Jeff will field those questions. And if you have questions, we strongly encourage you to do that. I will do my best to answer those questions. And if we don't have the answer, if that happens, I will be glad to get back to you later with an answer to your concern. So again, I thank you. Our goal is to educate, and we also want to give you a path forward. So sometimes people in my field, we give people, give the public, give advisors, give families a lot of information, but we don't want to just leave you with that information. We want to give you a path forward. How do I start the process of planning? How do I revise an older plan? How do I get my plan reviewed? We're going to talk about how you can move in a path forward. So we want to be a resource. And with that said, we have a lot of information to cover, a lot of information to throw at you within an hour to an hour and 15 minutes, but we're going to move through the information. If you have questions beyond today, please email me. Please email Jeff. I don't expect that you're going to retain all of this information, but like Jeff said, I want you to use the presentation as a resource And just know that you can always refer back to it and actually use it for many years ahead as a resource. So just know that if you don't get everything, it's okay. I hope you can walk away from this workshop with 1 or 2 or 3 concepts that will make a big difference for you down the road. So let's get started at the information. And Jeff, we're going to go ahead and proceed. So why plan? Why plan for a loved one with special needs? Well, you know, this is going to vary from family to family, but basically what we want to do is maximize a person with disabilities quality of life to the maximum extent possible. And we don't want to restrict their potential. And I know from hundreds or thousands of meetings with families with loved ones with disabilities, we are very keenly concerned about that. How can we maximize the quality of life for someone and not restrict their potential? And I know that is near and dear to many of you. It's on your hearts and minds. You don't want to restrict them or take away anything from them, and yet you're concerned about protecting them. So I want you to think in terms of special needs planning as this, in my mind. The government, I think, has done a fair job in recent years of providing an umbrella of services, waiver services that some of you are aware of and take advantage of, other services and so forth that hopefully will always be there. And hopefully those services will expand, even though we're in a time of economic turmoil and deficits and so forth. But I think that special needs planning is building a world for your loved one that is above and beyond that umbrella that's there. And of course, we want that safety net, that those public benefits, we call that. We want that safety net, but this is building a world of support outside of that. Hopefully that world of support, the umbrella world of support will always be there, but this is to supplement it. And God forbid if that umbrella was not there, to actually be a source of support if that umbrella was not there. So that's how I would think about special needs. The benefits of planning: each one of you is going to have your own situation, your own goals, but providing financial security, let's just walk through this list, is a big issue. If you don't have a financial advisor, and I know many families with loved ones with special needs do not have a financial advisor, please let us know. We work with the financial advisor community, and we can hopefully connect you with someone who can help you. We want to leverage means-tested benefits. So one of the problems we have in special needs is that families don't understand means-tested benefits, and advisors don't understand it, and worst of all, trustees don't understand it. So we want to understand means-tested benefits and how to leverage them. We want to select a proper team to manage the trust. What if the special needs loved one needs an advocate? What if we don't have an advisory team? What if we don't have a CPA? What if we don't have the advisor and the elder law attorney, the special needs planning attorney? We want to make sure that we have that. This morning I had a call with a person who is a specialist in life insurance. What if the special needs plan needs to be turbocharged with life insurance? Do you understand the opportunities that are available? These kinds of things are important. We need to plan for appropriate housing. I know that that is on your minds, many of you. How is my loved one going to have housing? Should I provide a house or a condo or something for them to live independently if that's possible? Or if it's not possible, how will I know that the supported housing arrangements are going to be there for my loved one? Ongoing system of advocacy, we talked about that. Who's going to be there to advocate for your loved one in the future to make sure that they're eating well, that they're not being abused, God forbid, that they are healthy and well. Planning for caregiving needs, this is a similar topic. Coordinating the entire family and their planning. Let's talk about that for a second. What if you did wonderful special needs planning? You have this wonderful supplemental needs trust, let's say, and you've done all the proper financial planning. You have all your assets coming into the supplemental needs trust, which we're going to talk about in a little while. You have all that done perfectly. But now there are extended family members, grandparents or siblings that leave, aunts and uncles who leave money for your loved one with special needs, and they leave that money in the wrong way, causing problems. causing problems where there's a loss of benefits. So we want to coordinate the entire family's planning, not just the special needs trust. So it's beyond that. We want to protect the beneficiary from fraud and abuse or predators, as we would say. And for some of you, it may be important to say, well, heaven forbid my loved one with disabilities dies sooner than some of my other heirs. I want assets to go to those other heirs instead of being paid back to the state of Maryland. So we'll talk about how to preserve assets for other heirs. So we talked about having an advisor team. We strongly recommend that. If you don't have a financial advisor, if you don't have a CPA, a tax advisor, we will be glad to help you do that or to coordinate a team and to make sure that there's flexibility in the planning, flexibility in the team, flexibility in communication within that team. That's important long term. It's a tall order. It's not easy to do, but starting that idea of coordination, that's important. Advocates, we talked about that briefly. There are various types of advocates that could be employed to be able to provide a life care plan. Some of you may have already had a life care plan for your loved one. National care advisors and other local advocates could be employed, and in some circumstances they can make a big difference, or even getting the advocate situated now during your lifetime prior to death and prior to the establishment of the further trust for your loved one. Trust protectors, we're going to talk about this. If you've never heard of this concept, this is a way to provide flexibility to any kind of irrevocable trust, but especially a supplemental needs trust, or what we would call a special needs trust. Trust protectors can literally do what it sounds like. Protect the beneficiary, protect the trust, and a trust protector is someone who is a special fiduciary that has limited powers. We're going to talk about this a little bit more. Now, some of this is going to be redundant on purpose because I want to emphasize some of the fundamental points so that when you walk away from today, you'll retain some of this and have some key points. So let's talk about what it means to create an effective plan. Well, what we want to do in our particular approach is we want to take the time to think. Jeff and I thought about this a couple of years ago after we've given hundreds of these workshops. And one of the things that we came up with and as a conclusion after dealing with many families is that many families, especially those with a loved one with special needs, just literally don't have a whole lot of time to think. So we want to provide a space to be able to do that. Where will your loved one live, and with whom will they live? This is something we talked about a few minutes ago. What is their level of care? To use a crude analysis, are they high functioning? Do they drive, or are they moderately functioning? Or no, they need a very high level of care. These are all parts of the analysis. Do I need a guardian or conservator when my child or loved one is 18 or older? This is a big thing that weighs on parents and grandparents' minds, and that is a counseling issue. So what kind of other planning is involved? What kind of lifestyle is desired? Do we want a purely supplemental kind of plan where we're trying to maximize public benefits and then supplement those public benefits with a trust? Or do we want to be more liberal and say, no, we're not purely going to do supplemental planning. We will allow our trustee, in their pure discretion, to pay for things, even if those items or services are paid for by the government. We want to build layers of protection. Do we have enough life insurance? Do we understand the protection of the beneficiary? Are we getting away from approaches that really put the beneficiary at risk? We want to build layers of protection, layers of planning, and we want to understand the process and the purpose. Let's talk about the process for just a moment. A lot of people are hesitant about doing planning, and rightly so in this world today. You're coming and you're sharing very personal information with someone you've never met before. What we want to provide, and what all special needs attorneys should provide, is a safe place to be able to come think and to enter into a partnership with your attorney to be able to accomplish your goals. It has to be that kind of comfortable relationship so that you can benefit, and there's a partnership on the attorney side, and there's an agreement that we're going to educate, we're going to do the highest and best things we can for the special needs planning and for the family overall. Okay, a memorandum of intent. So as promised, I'm throwing a lot of things at you, and hopefully you're making notes or you'll use this as a reference. What is a memorandum of intent? Well, some people would call it a letter of wishes. I call it a memorandum of intent in special needs. So here's a quick example. What if I had 1,000 wills right here with me, stacked up? What if I had 1,000 special needs trusts stacked up? Here's a question for you. Would those look similar, most of them, or would they look different? And I'll go ahead in the interest of time and answer that question. Most of them are going to look pretty similar. And it's because what happens in planning over time is that a lot of documents are used that look similar. What I'm going to encourage you to do is think in terms of, I don't want to use a typical or older templated document for my child's planning or my loved one's planning. I want to use a modern, contemporary document, but I'm going to attach a memorandum of intent. The memorandum of intent talks about what are my child's preferences or needs? What are their medical issues? What are their eccentricities? Who are the key people? If you keep this memorandum, it's a lot of work, but if you keep this memorandum in Word format or some other word processing program, you can update the memorandum of intent about every 5 years or so. And it's a living document that can be attached to the back of the Supplemental Needs Trust, which we're going to talk about. And this is possibly the most important tool in special needs planning, the memorandum of intent. So I just want you to know the memorandum of intent is not required, but it is one of the key issues or one of the key features that separates your Supplemental Needs Trust, whatever that may be, in whatever form it may be, from everybody else's trust. Jeff, I'm going to stop just a second and see if there's any questions. I know it's a little bit early on.
Yeah, thank you, Steve. Looks like no questions just yet, but I'm sure there will be some coming. Thank you.
All right, well, it's early and maybe people are drinking coffee or tea. All right. So what should you do, generally speaking, with regard to some of these issues? Well, we want to look at income and expenses, and we want to look at Social Security, housing, how will shortfalls be met, use the resources of financial advisors. Jeff and I and all of us here at Elville and Associates, we're not financial advisors, we're attorneys, but we do work with a lot of financial advisors, and we give trainings to a lot of financial advisors about legal issues. We strongly recommend that you use the resources of a financial advisor. For example, many financial advisory firms have special tools to look at problems with special needs and to make projections. And those advisors who are on this video webinar, they know what I'm talking about. There are things such as Monte Carlo simulations and powerful tools. I strongly recommend you take advantage of those things. And if you don't have those resources, to ask and we will help. Now, here's a really simple spreadsheet, but this is a little bit antiquated at this point in our world today. You can find things like this on the internet. You can use your financial advisor's resources, but I do strongly recommend you start thinking about this. Why? Well, before I go to the next subject, think about this. The special needs families that I meet with, not all of them are wealthy. We have some wealthier folks, we have some not so wealthy folks, and as you well know, special needs doesn't discriminate. And all kinds of families and all kinds of situations have loved ones with disabilities. So most of us, when we think in terms of, well, what will I leave to the Special Needs Trust? What will I leave for the benefit of my child with disabilities versus what will I leave to other children I may have that are neurotypical healthy children? Well, most of us can only think in terms of, well, we will leave whatever we have at our deaths. But see, we don't know what we're going to have at our deaths. That's the problem. We don't know how much it's going to cost for long-term care. We don't know what is going to happen in the economy. We don't know how much it's going to cost us in retirement to live prior to our passing. So I strongly recommend that we think in terms of using financial advisory resources, including life insurance, to turbocharge or to look at how are we going to leave the proper amount of money for the benefit of our loved one in the future. Now, many people are concerned about how do we plan for incapacity for our special needs loved ones. So this is a very brief discussion I will have here. Higher functioning children who or loved ones who have mental capacity, they are able to appreciate the nature of decision making, and there are many people with disabilities in this category. They should absolutely sign advanced medical directives and powers of attorney, because why? Once they do that and they appoint agents for healthcare, agents for their financial affairs, and I would point out, sign a HIPAA waiver, an additional HIPAA waiver, even though the advanced directive does have a HIPAA waiver in there. When they sign that, they are putting themselves out of a position of ever needing guardianship. This is very similar to everyone who may be healthy on this call with no special needs. That is the same concept. If we sign these documents and appoint agents, we are basically avoiding guardianship or conservatorship. Now, what happens if a child does not have the mental capacity to do this? Well, guardianship is there. Guardianship is the highest form of intervention. It does take away someone's legal rights, and many times that is necessary, and it's a counseling issue. So this is something to work through. Supported decision making. Maryland does not have supported decision making. What is that? Well, it's a form of decision making that basically allows a person with disabilities to maximize their decision making potential without the need of a guardianship. And the idea is that people with disabilities can make decisions for themselves to some degree. Even if they are significantly impaired, they can still make some decisions as long as they have the proper support. Well, sadly, Maryland does not have supported decision making, but Delaware has it, DC has it, Texas has it, of all places, Indiana has it, and Alaska has it, and I believe Wisconsin has it, and maybe some other states. But those few states have it. We are trying to advocate, as are many others in Maryland, that people with disabilities should have a decision, or excuse me, an opportunity or a choice other than just signing advanced directives and powers of attorney or having guardianship. There should be a middle ground. And in some states, a person can actually be under guardianship and still have a supported decision maker. So hopefully this is something that will come to fruition. I'm involved, very fortunate to be involved in a documentary film project about trying to help support or promote the supported decision-making concept. And if you're interested in finding out more about that, please let me know. But the idea here is to understand that people with disabilities can still sign advanced directives and powers of attorney, or if not, there may be a necessity for a guardianship, but hopefully someday in the middle there'll be a choice to be able to appoint a decision maker that will help them make decisions as much as possible. Now let's talk about public benefits, and we're going to spend a little bit of time on this. This is critical for you to understand. It's critical for your trustee to understand. So I'm going to try to break this down into categories just for the interest of time here, and also for your sanity to try to understand this. So many of you are aware of these things already. Many of you have children who are past the age of 18 and are on SSI, Supplemental Security Income. And let's break this down into three categories. So I like to think in terms of means-tested public benefits as Supplemental Security Income of SSI. And this is the quintessential definition of disability. Someone is receiving SSI, and it's about $785 a month. And as a result of this, by going to social services after qualification for SSI, that person with disabilities will automatically get medical assistance which is Medicaid in Maryland. So we have the type of beneficiary, if you don't mind me making these series of categories. We have the type of individual who is on SSI and as a result is getting medical assistance. That is a means tested benefit that many of you are aware of, that individual cannot have more than $2,000 of resources in their name, $2,000. So that hasn't changed much for many, many years, and hopefully it will change in the future. But now let's move to the second category. This is a person who is on Social Security disability, not necessarily supplemental security income. So many of you know that Social Security disability is something that you would get if you were unable to work and you qualified for disability. There are two ways that a person can get this. This is on their own work record. I'm getting Social Security disability because I'm disabled on my own work record, or I'm getting Social Security disability based on my parents' work record because I was a person who was disabled. I'm an adult disabled child. Prior to age 22, I was disabled. So Social Security disability in and of itself is not means tested. I could have $1 million in the bank and still be on Social Security disability. It is not going to, my $1 million is not going to affect the Social Security disability. However, there are people who are on Social Security disability who also are on medical assistance. And that is the person who has low resources. They still have less than $2,000 in their name. So the person in this middle category could still be a person that needs to be concerned about preserving their means tested public benefits, even though they're in the middle category. So again, to try to clarify this, the person on the left here is an SSI recipient. They automatically get medical assistance as a result of that. That is a very important thing because prior to the public exchange for insurance or Obamacare, this is a critical thing and could be in the future. What if that person lost their SSI? They could theoretically die because they have no medical assistance because they lost their SSI. Very important to keep that person under $2,000. But the person in the middle category could be the same in the same situation. They are receiving Social Security disability. They are receiving Medicare because of the Social Security disability, but also they could be receiving Medicare and medical assistance because they have low resources. So many, many people on the left-hand column here, they receive, when their parents or other relatives pass away, they should receive a supplemental needs trust for their benefit to preserve their SSI and their means tested benefits. The person in the middle should also be planned for in the same way if we're trying to preserve means tested benefits or protect them from fraud and abuse and so forth. We're not going to spend very much time on the right-hand column, but there are people who live in Section 8 housing or have veterans benefits. And what I'll say about the Section 8 housing is this is the most difficult special needs trust to administer. For the person who is living in this type of housing, what we'll call HUD housing, HUD is very difficult to deal with because HUD will actually say any distribution from a special needs trust is going to potentially increase the rent of the person because that distribution is going to basically increase income. So there are some techniques that can be used with the ABLE account. So the Maryland ABLE account can be used as a tool to deal with this problem. And we won't go into that right now, but we can deal with that. So 3 types of categories of individuals, if you don't mind me saying so, that we kind of frame public benefits by looking at that. Now, I'm not going to spend a lot of time on SSI qualification, but you can use this as a tool. There are tests the person has to meet. We do have resources of very talented attorneys who can help your loved one apply for SSI if they need to. And you should not be shy or concerned about that. It is a pretty seamless process to get that started. So don't hesitate to let us know if you need help there to get that process started. And as I just mentioned, at the SSI resource test is $2,000. I actually did have a couple once in their 70s, a couple that was receiving SSI, and the eligible couple can have $3,000 of resources, but the individual that we're normally dealing with can only have $2,000. Now notice here that some resources are exempt. So a person with SSI can still own a home. That doesn't mean it's a good idea to own the home, that maybe they should not in any way be owning that home themselves. Maybe their trust should own the home, but they can own it. They can own an automobile, same situation. Maybe they have no business driving, but it's not going to hurt their qualification. And then you'll see some of the other things that are exempt for a person that receives SSI. And of course, SSI, I said 785, excuse me, it's 783 a month. We're going to have to look at the 2021 number. Jeff, I didn't check that. I apologize, and I didn't put that in here, but we can supplement this with the 2021 number. So the rate is, at least in 2020, was 783. I believe it's gone up to about 780, 785 or more. And some states provide a supplement, so just know that. And of course, in California, if you can imagine living on less than $800 a month. But remember, it's for food and shelter. That's what it was designed for. So that's an important concept to remember, okay? And we also have to be concerned if we're dealing with a loved one with SSI, we don't want them to ever lose their SSI. So for example, I was just talking to an adult disabled person the other day, around 60 years of age, and this person is very industrious. They want to work, they want to be active and useful and feel good about working, but they have to be concerned because if we look at these formulas of unearned income and earned income, we have to be concerned that if this person earns too much income, it will reduce their SSI to 0. And we never want that to happen because that will eliminate the medical assistance. So this is one of the problems, is the person who wants to be productive could earn too much money and eliminate themselves from SSI. Now, in-kind support and maintenance, many of you understand what this is. If you have a child living at home and that child is receiving SSI, remember that child is not paying for support and maintenance. You are providing that for them. They're not paying for their shelter and so forth. So what happens is that the SSI will be reduced by 1/3. So many of you have experienced this, whereas if that child were paying rent, and it is very easy to prove this and very easy to go to a system where the child is paying rent, even though that's counterintuitive to many people, then we don't lose that 1/3 reduction. And that 1/3 reduction may not seem like a lot of money, but it can add up over the year. So we don't want to lose the 1/3 if possible. SSDI, I'm not going to go through these formulas with you because you can see this as a worksheet, but SSDI is a similar process. Many of you are aware that if you don't qualify for SSDI right away, it can spin off into a long process of, well, maybe I'm going to get approved on a reconsideration after I've been denied. And if I don't get approved on the reconsideration, then I may have to wait a year or two for an administrative hearing. So that's painful. So we strongly recommend that if you're thinking about applying for SSDI, that you use a professional and that we get as much information or medical information up front as possible so that you're trying to avoid that 1 or 2 year process of an administrative hearing. So there are professionals there that can handle that. Now, you heard me a few minutes ago mention the childhood disability beneficiary or the disabled adult child. So remember, this is a very important thing that I find that many special needs parents and grandparents have no idea about. And it basically says that if the child was disabled before 22, they're going to receive 50% of the Social Security amount of the parent once they are retired, disabled, or deceased. And after the parent's deaths, they're going to receive 75%. So this is a very good piece of news for most people who are not aware of this increased benefit. Let's frame this a little bit more. For those of you who have loved ones who are on SSI, that SSI beneficiary could have been, and maybe probably is, a person who was disabled before 22. Not everybody, but many people are on SSI and they're disabled before 22. That person who's on SSI and medical assistance is going to transfer into being a person who is receiving SSDI when their parent retires or dies. They're going to transition from SSI to SSDI, and remember my chart, they're going to receive Medicare and medical assistance. If they have low assets, they're going to receive medical assistance. So this is a big benefit to be aware of and not to forget. The disabled adult child benefit. Now, Medicaid and Medicare, I'm not going to spend a lot of time on these because we have a limited amount of time, and many of you want to get to the special needs trust planning. But just know these are the parameters for qualifying for Medicaid and Medicare. We talked about Section 8 housing and how people have great concerns about this. Of course, there's nothing wrong with HUD housing. We actually are aware of some very upscale HUD housing in downtown Rockville. But we just need to know that giving money to a beneficiary to pay for their rent, or giving money to a beneficiary, or distributing money from a special needs trust to a beneficiary can actually increase their rent. So I'll give you a real quick example. Let's say someone is disabled, they're living in HUD housing, and they're receiving gifts from family members to supplement their lifestyle. They're receiving $1,000. Now this person, let's say, is not on SSI, so this is not going to disqualify them. Let's say they're receiving SSDI, so it's not going to disqualify them. But this $1,000 was just to help them. It was just to supplement their lifestyle. $12,000 a year. It's nice, very nice gifts that are being made to this person. Well, that is going to increase their rent, and that's going to be a problem. But if the same $12,000 were contributed to an ABLE account, an Achieving a Better Life Experience account, and that ABLE account was used to supplement the person's lifestyle, then the HUD housing situation would not be a problem and it would not increase their rent. All right, so housing is a very, very big concern for many of you. It's a counseling issue, it's an estate planning issue, it's a financial planning issue, and I strongly recommend, if you're concerned about housing, that we talk about that collaboratively with a team. And of course, purchasing a home for your loved one is not a bad idea if they can live independently or live with others. It can actually be owned inside of a supplemental needs trust where it's safe and where the trustee has control of it, or of course they could own it in their own name. So every situation is different. All right, Jeff, so that was the precursor to the discussion of special needs. I'm looking at my watch and it looks like we've gone about 45 minutes. And I think we have at least another half hour to get through this before questions. Jeff, do we have questions that are the interim kind of questions right now?
Not just yet, Steve. So a little bit of a quiet audience to this point, but I'm sure they will come. I know they will come. And just as a sidebar, and I apologize for missing that SSI number. That's something that I should have caught, but I did look it up, and the number is actually for 2021, $794 a month. I'm sorry, a year per individual. So
per month, I think, Jeff. Yes, thank you.
Per month, yes, I apologize.
Yes, thank you. Thanks for looking that up.
I'll note that in my follow-up message to everybody after the webinar a little bit later.
Thank you very much. All right. All right. Well, it is Wednesday. It is hump day. So I know a lot of you are probably writing down so many notes you don't have time to ask questions, which is fine. All right. So let's get to the special needs trust portion. And I want you to think in terms of special needs trusts as part of your estate planning. So the first kind and the most important kind we could talk about today is the third-party trust. And you'll see this chart. And I want you to think about the third-party trust as the bread and butter special needs trust that families will use when planning for their loved one. And this can be established, look at this, it can be established by anyone except the beneficiary. It can be established by parents, grandparents, siblings, the source of funds can come from anyone except the beneficiary. So this is very important. This is the funds of a third party. So what do we call this trust? The official name, in my opinion, is this is the third party supplemental needs trust. The third party supplemental needs trust, and the distribution on the death of the beneficiary, heaven forbid they died prematurely, that is going to be up to the grantor. So this is the kind of trust that can protect your loved one's benefits upon your passing, and it will live in perpetuity. And then at the death of the beneficiary, it will go according to the wishes of the grantor, meaning it'll go to other children or other family members with no payback to the state of Maryland. So the third-party supplemental needs trust is the quintessential planning document. It's very flexible. We're going to talk about the features of it in the modern world today. And now we go to the second category. And the second and third category are what we call first-party trusts. So we have third-party trusts, which are basically a way of saying this is not the child's money, whereas, or not the beneficiary's money, this is coming from third parties, whereas the first-party trusts, and you'll see the first kind here, the D4A Trusts. Now, where does that come from? Well, it comes from the United States Code, 42 USC 1396, and so forth. And we can get that reference for you if you'd like to see it. But the code section is section D4A of that particular code. And it says, according to federal law, and of course a state law, is that if the beneficiary comes into money, so let's say that the uncle, the well-meaning uncle, did not listen, and he did not know, and he left this wonderful gift to the disabled loved one and did not leave it to his or her third party supplemental needs trust. Now we have a beneficiary, a disabled person who has a lot of money in their name that they should not have. They're going to lose their benefits. They're going to lose their SSI, let's say. They're going to lose their waiver. So now we have a problem. But the good news is that this first party trust can be created, and that money can be transferred to that trust, and it can shelter the assets so that the person can get back on their benefits. So this is called the first party D4A trust. It has to be established before the person is age 65, and it can be established by, look who can establish this, a parent, grandparent, guardian, court, or, and this is a recent development over the last 5 to 7 years, the disabled person themselves, if they have mental capacity, they can establish this trust. Now, this is a payback trust, so we don't want to do this unless we absolutely have to, but it sometimes is a good idea to have this trust already established and approved, and it doesn't cost a lot of money to do that. Have it established and have it approved by the Attorney General, just in case someone leaves money that they shouldn't leave to the disabled loved one. There is a payback to Medicaid. So for all benefits paid by Maryland or any other state, it has to first be paid back at the beneficiary's death if there's any money left in there. And then after Maryland or other states are paid back, it can go to other beneficiaries. Now, the pooled trust is used for people who are over 65, or it is used for someone who just does not want to spend money on establishing the other one, in my opinion. They're run by nonprofit organizations. There's a few of these in and around the mid-Atlantic and across the country. And there is a payback to Medicaid, but this is a pooled type arrangement, okay? And my preference, generally speaking, is the D4A trust, but there are circumstances where the pooled trust can and should be used, especially if the person is over 65 and they need to get money out of their name. So what I hope you see with this chart is that for estate planning purposes, the third-party supplemental needs trust is really our go-to document. The D4A trust is a trust that can be approved and be on standby. So the highest and best kind of estate planning for special needs is to use the supplemental needs trust, or and in conjunction have a D4A trust on standby so we can cover all potential contingencies, hoping that the D4A trust is never used. I want to give you one situation where the D4A trust is necessary, and that's for you veterans who might receive or will be receiving a military pension or are receiving a military pension, and you have a loved one with disabilities. You can assign, according to a new law about 5 to 7, 8 years ago, you can assign the special needs trust your military pension, and that has to be a first party trust, the D4A trust. So that's a wonderful thing for people who receive military pensions. So again, the third party trust is the best method for providing instructions and providing an inheritance that does not disqualify the loved one from their benefits. It allows flexibility, it allows control. And we want to use the supplemental needs trust almost 100% of the time, because there are other arrangements that are not so highly recommended. So let's look at those. And some of you may have even seen this or done this. And of course, it's easy, hopefully, to undo this if you've done it. So an outright inheritance, if we leave an outright inheritance to someone who's on SSI or means tested benefits, obviously they're going to lose their benefits. And what happens? We have to use a first party trust to save that person's eligibility. Now, I will point out something about a first party trust that I failed to mention. The D4A trust is there. Let's say that well-meaning uncle left an IRA to the beneficiary, not just cash, they left an IRA. Well, anytime an IRA is transferred to a trust during life, that trust is going to trigger taxation on that IRA. Well, this is the one time that Uncle Sam allows an IRA to be transferred to a trust with no tax. So let's say a disabled loved one received an inherited IRA, and that was not good. That knocked them off of benefits, it hurt them, and now we have to establish the first party trust. So we do, well, depending on the situation, but very likely, we will be able to move the inherited IRA from the disabled person into their first party trust with no taxation. That is what federal law allows. There are many private letter rulings allowing this, and we want to take advantage of that. But what we don't want is assets left outright to people where we're put into that kind of circumstance. Left in a non-qualifying trust. So let's say that someone wanted to do special needs planning, but they left assets into what I will call a general needs trust, not a special needs trust. They left the assets into a health, education, maintenance, and support trust, like you would leave to a healthy child or a healthy loved one. That will cause a loss of SSI and Medicaid because the word support. So health, education, maintenance, and support. Maintenance and support is where we go off the track there, and it becomes a trust that will cause a disqualification. So we have to have a discretionary trust, or what we would call a trust where it's supplementing, not supplanting, supplementing the person's lifestyle, and it does not pay for their health, education, maintenance, and support. Disinheritance. Some people say, well, I'm just going to disinherit my loved one. Well, that's not going to be a good idea, because what if we leave assets to others? So let's take a look down here at this last bullet point. What if we leave assets to siblings to take care of our loved one? Well, this is generally a bad idea for those of you who have not seen this before. What if the sibling has creditors? They could lose the money. What if they die and they pass those assets on to their spouse, and then the spouse remarries? Those kinds of things obviously can happen. What if they don't end up taking care of their loved one and you've ended up leaving them the money? Or what if they get divorced and they've commingled this money with their spouse, their divorcing spouse? So we don't recommend these kind of arrangements. Obviously, they're very risky. We want to use, generally speaking, the supplemental needs trust. And again, the third party special needs trust, or what we will more accurately call the supplemental needs trust, the beneficiary, again, does not create the trust. The trust does not own any of the beneficiary's own money. It's third party money coming in there. And the trustee has discretion. It is a discretionary trust under Maryland law, and other states are pretty much the same. It is not a general needs trust. There's no payback required, and the grantor can leave remaining funds to whoever he or she wants. It can be revocable. So even though when I was a young lawyer, we used to draft these trusts as irrevocable all the time, it can be revocable during your life, because what if you just want that flexibility? You don't want to have to pay taxes on an irrevocable trust. You may be not planning to leave money to this trust until your death. So why have it as irrevocable? When you might have some flexibility to change it in the future. So all kinds of things can be done for flexibility. Now, trustees, let's get into this topic. Jeff, I'll just stop again real quickly to see if we have any questions.
Thanks, Steve. We do have a couple. And the first one is, our special needs son will be eligible for SSI once he turns 18. He will also get Medicaid at that time. However, once I retire, he might be 20 years old, he will also get SSDI via me. At that time, can he still be eligible for SSI and Medicaid?
Well, thank you for that question. And it's difficult, in these formats for me to understand all of the nuances of your question. But if I'm understanding it right, once you retire, your child should receive SSDI and Medicare eventually, and they would no longer receive SSI. Now, this is generally speaking. Obviously, this is not legal advice and that kind of thing, but generally speaking, once they transition to being an adult disabled child status, they would not receive SSI. Now, some people receive a combination of SSI and SSDI, but I believe if you're a typical person who has had a career and the child is going to receive a fairly substantial amount as an adult disabled child, my take on your question would be the SSI would go away when that transition occurs.
Okay, thank you. And the next question is, are you suggesting that we set up a first party D4A trust to have quote unquote just in case someone leaves my daughter money?
Yes, that is a great question. And I want you to understand it's not necessary to do that, because it's always possible to establish the first party trust when it ever would be needed. But if we look at special needs planning as kind of what do I do as the highest and best planning? Well, it doesn't take a whole lot to put together the first party trust. That is a templated trust. We are not allowed to actually customize that too much. It's got to have certain provisions in it to meet the state and federal requirements. And it doesn't cost anything to send it off and have the Attorney General approve it. And when I was a much younger lawyer, it used to take 6 to 8 months for the Attorney General to approve it. Now we get them approved in 1 or 2 months because of increased efficiency and the email and so forth, and electronic means. So, but in the highest and best world, I think all parents would have this first party trust established, and it would just sit there. It doesn't create any reporting requirements. It just kind of sits there. And if it never receives any money, all we end up doing is letting the state of Maryland know that there was never any money in it, and it just goes away. So I do think that is the highest and best form of planning, although
Okay.
it's not required.
Okay, and another question. If money is left to a disabled beneficiary within an educational type savings account, could this also affect their SSI/Medicare, etc. benefits, assuming this educational funding would be used for private school/trade school, etc.?
Yeah, I'd have to see the specifics of your particular approach and what that account is. But my answer to that would be no. It should not affect their benefits. But I would like to see, if you have further questions about that, you can please email me. What you're specifically talking about and what your plan is, or plan that you've already put in place.
Okay, and last question for now. Can you repeat the phrase you mentioned? The special needs trust should supplement the person with a disability and not pay for health, education, and support, etc. I
That's a
think I know
great
what
question.
you
Thank you.
do, but I'll let you do it.
Thank you. So there was a case about 50 years ago called the First National Bank case. And there must be a million cases called the First National Bank case, but this one had to do with a special needs trust that was created by a family for the benefit of a young lady who lived at Crownsville Hospital. And this was before modern times in special needs planning. And the court, the Court of Appeals, was basically asked to determine, is this trust a support trust, meaning it's an available resource and the state of Maryland should be paid for what it has been paying for this young woman who lives at Crownsville Hospital, or is it a discretionary trust? And to make a long story short, the court found that the trust in question was just a little bit of both. And the ruling basically was this, that there are support trusts and there are discretionary trusts. And support trusts are an available resource. So I'm using as an example, obvious support trust, a trust that we see millions of in estate planning, where someone leaves a child a trust and says, this trust is for the benefit of this person for their health, education, maintenance, and support, HEMS. So that's a surefire signal that is a support trust. And that would disqualify a person from public benefits because they have received a trust that disqualifies them. So we have to make sure that that doesn't happen. Now, let's say that did happen. There are ways of being able to fix that. There are ways to change that trust to a special needs trust, but we would rather not have to do that. Going back to the First National Bank case, the discretionary trust is what is exempt. So a supplemental needs trust or the first party trust, those are considered to be discretionary trusts. So I'll give you an example, and this is rather scary for parents. My trustee may pay for the benefit of this person, of the disabled person, but does not have to. You see, that kind of language is what sends the signal to the outside world. This trust is not owned. This trust is not the money of the disabled beneficiary. It is purely in the discretion of my trustee. And so I hope that helps. And Jeff, any other questions?
Not at this time. Thank you.
All right, thank you. And that leads us to the importance of choosing a trustee, because if you've got a trustee who has pure discretion over the trust and you're relying on that trustee, right? So who is the trustee? Is it a family member? Is it a professional? Is it an attorney or a CPA? So we want that person to understand many things. And of course, we want them to read the trust. And many trustees, believe it or not, never read the trust. So that is a problem we'll talk about in just a minute. So they want to understand complexities of SSI rules and tax reporting. It's going to depend on the amount of under management. It's going to depend on whether you want oversight of that trust. Many people will establish trust and really say no bond is required. That is a typical approach because bond is very expensive and it can deplete the trust. What is the relationships in the family? Are there family members that can serve? What are the trustee fees going to be? Is there a conflict of interest? What is the person's knowledge and experience? Are they really willing to serve? I know many of you are concerned about this. It is not uncommon, and I don't want to scare anyone on the call, it is not uncommon to reach the point where the plan comes to maturity, you have passed away, and the person who has been chosen may not be willing to serve. This sometimes happens with corporate trustees where they will refuse to serve if the portfolio doesn't look like they want it to look. So you have to plan for flexibility. You have to think through this issue of trustees. We're going to come back to this in just a few minutes. Now, we're going to get to this issue of trust protectors, which is going to give some of you some peace of mind about trustees. I'll get to that in just a second. A modern trust might use a trust advisory committee. So this is a situation where the trustee has questions, they have some big issues they're dealing with, and they need advice. This may not ever happen. This may not ever be needed, but we like to include a trust advisory committee provision in a special needs trust to say, if the trustee needs to convene a meeting with the social worker, the caseworker, the psychiatrist, the family advocate, whatever it may be, that trustee has the ability to do that for flexibility. Now let's get back to trust protectors and trustees. So some of you are going to be very concerned about this issue of who's going to be my trustee, especially with what Steve is saying about, well, what if I choose someone, I go through the process and then ultimately they refuse to serve. That doesn't happen a lot, but it does happen. We want to provide for flexibility. So what does a trust protector do? The trust protector has authority to make changes to the trust. What if the special needs laws change? What if the country changes, as we've seen many times? What if the attitudes towards special needs and the laws and the waiver programs, what if these things change and the trust has to be modified? The trust protector can do that. But look at the second bullet point here. The trust protector can remove and replace trustees. So all you can really do is design the trust the best you can, maintain the trust. Now, this is something that Jeff and I will emphasize many, many times. It's not just enough to establish the trust and forget about it. You want to maintain the trust every few years to review. Is the situation the same? Do we need to revisit anything? And I know some of you on this call are revisiting existing trusts that are already in place. But that trust protector power to remove and replace trustees is very important because that gives flexibility down the road. If a trustee refuses to serve, a trust protector can appoint a new trustee. Trust protectors can be given the authority to review accountings and mediate disputes. So let's just take a look at a third-party trust. Jeff, I'm checking my time. It looks like we have about 5 more minutes or so before we would have more questions. A trust in today's world might look like this, a special needs trust. We have trustees, which we've talked about. We have a trust protector, which we've talked about. Trust protectors are not required, but I strongly recommend it. We would have a provision that says a Maryland Able account could be funded. Okay, so this is for someone who is qualified for a Maryland Able account. We want the trustee to know there are advocates that they can hire. We want them to know. We don't want them to just go through the process and not know what they actually can do. We want you to form a memorandum of intent to make your trust for your child this as personal as possible. We want that trust advisory committee. Now, some families don't want that provision, but I strongly recommend that it's in there as an optional tool. And maybe more importantly today than ever, we want to have special retirement plan provisions. How many of you have heard of the Secure Act? President Trump signed that in December of 2019. It became law in January 2020. And the Secure Act basically means this to the people on this call. Healthy, neurotypical children are not exempt, and they are going to have to pay taxes on inherited IRAs. They're going to have to pay all the tax within 10 years or less. Many of you are becoming more familiar now with the Secure Act. This is not good for families. It's not good for planning. It means that Uncle Sam is going to accelerate taxation on trillions of dollars of IRA money much quicker. The good news is that your special needs loved one, your disabled loved one, is exempt from the Secure Act, and the lifetime stretch out of the IRA money that they will receive as an inherited IRA can be stretched out and tax deferred for their lifetime, with them taking only minimum distributions in the way that it used to be prior to the Secure Act. So not only is your disabled loved one exempt from the Secure Act, but their special needs trust or their supplemental needs trust is exempt. Now, we have to make sure that the supplemental needs trust is drafted properly, because if we didn't do that, we're going to have something even worse happen. We're going to cause a 5-year distribution and not even a 10-year. So your disabled loved one is exempt, but the supplemental needs trust has to be drafted properly to take into account the rules relating to retirement plans. And that's a very, very big deal for many of you who are saving most of your money today in retirement plans. But this is what we're looking at as the structure of an ideal supplemental needs trust. Now, Jeff and I were looking for pictures of what we thought were perfect individuals, and we came up with these two people, and these people are trustworthy. Let's look at what they do in these concentric circles. They have the best interest of the beneficiary in mind. They're strong advocates. They understand public benefits. They always promote independence and quality of life. But at the same time, these people are wonderful record keepers. They keep the beneficiary informed. They treat them with dignity and respect. They comply with their statutory duties, and they don't try to do everything themselves on the financial side. They hire professionals. They understand they have a fiduciary responsibility with the trust funds, and they understand taxes, and they file the taxes appropriately for the trust. So these kinds of individuals, this is the ideal thing of what we're looking for in a trustee. The whole issue of whether we should have an individual trustee or a corporate trustee, we do talk about that in a separate workshop. So please know this is a counseling issue, and we're here to help you with this. Now, what can a special needs trust pay for? In the interest of time, I'm just going to say a first-party trust has a little bit more limitations than the third-party trust. And Jeff and I will be glad to send you a list of things that a special needs trust like a first-party trust can pay for. The third-party trust is more broad and it's a little bit more flexible. But think of the third-party trust. It can really pay for anything that the beneficiary needs. The first-party trust is a sole benefit trust. It can only pay for things that are solely for the benefit of the beneficiary, and it's more regulated, even though it's still quite broad, but we will be glad to send you that list. All right, in the interest of time, how much should I fund into this trust? Okay, well, we talked about financial planning. Some of you, some of us, we can only plan for what we have at death, and maybe that we're just going to have to be satisfied with this. But I strongly recommend that before you come to that conclusion, that you have your financial affairs analyzed to really project and to really see the tools that are available to you with working with a financial advisor and an advisory team, like your special needs attorney, your CPA, and your financial advisor. And again, if you do not have a good financial planner or good advisor, and you're looking for another one if you already have one, we are here to help you to do that. But understand that they provide a lot of value, and you can benefit from that. We talked about the first party trust. These are used if the beneficiary comes into money they shouldn't have. The genesis of this kind of trust really is the person who is injured, heaven forbid, in a car accident or a train accident, or there's a birth injury. Many of you are familiar with this. This is the same kind of trust, that D4A trust, that will preserve that person's benefits while having that money segregated out there for their supplemental needs. So again, this is usually a personal injury award or inheritance and so forth. And again, as that nice person asked in their question, we want to implement this as a highest and best approach, even though it may not ever be needed or currently needed. So what is the process as we try to wrap up? This rather colorful illustration is our method of saying that to give you time to think, we want to give you a process. So special needs planning, like estate planning, should be a process, number one. It shouldn't be a quick, really quick 1 or 2 meetings. It should be a process of review where you have the time to think, you have time to be counseled. And this chart is really just to show you the process of what we believe should happen in special needs planning. We want to educate you. We want to give you the time to make decisions with the information we're giving you. And we want to connect you with an advisory team if you don't have one. We also want family members and loved ones to come and meet us to see what their responsibilities are. We are trying to be comprehensive, and we strongly recommend that approach. And then after the planning is done, we recommend that you continue to educate yourself with webinars and client care events and so forth, and client care program events that we do. So we want you to think in terms of special needs planning as a process. This is kind of a narrative form of what I just showed you. And as we start to wrap up now in the next 5 or so minutes or so, Again, we talked about getting back to how do we think in terms of decision making for people with disabilities. Again, there may be necessary to have a guardianship or conservatorship, but if we can avoid it, we should, as long as it doesn't put the individual at risk. Many people are right there on the borderline of maybe they could go without a guardianship, but they are still very vulnerable. So this is a one-on-one specific situation to you that is really a subject of counseling. So I'm not going to spend a lot of time going through guardianship or conservatorship, but there is guardianship of the person, guardianship of the property, or guardianship of the estate. So most of the time in special needs, it's going to be guardianship of the person, unless the child or person has assets in their own name, which many times they don't, because if it's only SSI or SSDI that they receive, that is going to be a substitute for guardianship through something called the representative payee. Many of you are representative payees for your child. So making decisions, and how do we go forward from here? So we want to consult with you. We don't charge for that. We will review any documents that you have that are existing. We want you to complete an estate planning questionnaire. We want you to understand there's nothing to be concerned about. You can relax. You can bring your current documents. Don't be ashamed if you haven't updated your documents for many years. The average person either never updates their documents at all, or they update them only 19 or 20 years at a time. So don't be embarrassed by anything. Consider your advisory team. If you do have an advisor, a financial advisor or CPA, we want to meet them. We want to collaborate with them. Bring your questions, and we will give you time to think. That's what we want to do, is give you that space and to educate you. So creating a memorandum of intent is part of the estate plan as we establish your estate plan, whether that's a will or a revocable trust as a basic estate plan. And after those basic estate planning documents are created, we also establish, or part of that, we establish the special needs trust. Some of you have wills or trusts already for yourselves, and you're just interested in establishing a supplemental needs trust, and that's fine too, because we can establish that and then we can make adjustments to your other plan, parts of your plan. We want to calculate financial needs. We want to make sure that the special needs trust or supplemental trust is the beneficiary of retirement accounts, and we want to make sure we've thought through that issue of the Secure Act. That's a very big issue that has to do with taxation and how do we avoid that for your loved one with disabilities. We want to understand public benefits. We want to educate our trustees. We want to start naming those persons who will be the advocates. We want to make the special needs trust an integral part of your plan, and now you have peace of mind and you have a basis to go forward in the future to maintain that plan. And our belief is, if you establish your plan, no matter what kind of plan it is, you maintain that plan and continue to educate yourself and make sure that all assets are aligned with the plan. And in special needs planning, making sure that all assets of the broader family who may leave money to the beneficiary, that all of those things are aligned. Now the administration is going to be the easiest administration possible after your passing, and everything will work the way it's supposed to. And we can avoid the first party trust. We can avoid your loved one getting money that they're not supposed to have, and avoid a payback to the state of Maryland. Maryland Able, I'm just going to include these slides. This is a wonderful thing to enhance the lives of beneficiaries. Jeff will talk about perhaps when we may be presenting again with Maryland Able, and Jeff can talk more about that. But we have been very blessed to work with the nice people from Maryland Able, and they are very educational, very helpful. They will help you and I establish ABLE accounts. I just told a paralegal this week we have to get 2 ABLE accounts established for 2 individuals, and we know that we're going to get plenty of help from Maryland Able. There are a multitude of benefits to opening an ABLE account. I would say it's not appropriate for every single disabled beneficiary, but for the majority of people, it is going to enhance their lives. It is going to give them a sense of independence, and there's many, many benefits. There's tax benefits and so forth. So I'm not going to go through every single slide here about Maryland Able, I'm going to strongly encourage you to contact Jeff and get him to send you the latest links on Maryland ABLE presentations that we've done here at Elville and Associates. And one of the last ones we did, I think, Jeff, was one of the best ones we've ever done. And the feedback we got was tremendous. So Jeff can certainly send you that link all about Maryland ABLE instead of me going through it here. And I think we're out of time anyway. But definitely Maryland ABLE is going to be a great tool along with a supplemental needs trust. It is not a replacement for a supplemental needs trust. For example, you can't at your death leave a lump sum to an ABLE account. So I think that's one of the things that confuses people. I want you to think in terms of a supplemental needs trust as part of your estate planning and a Maryland ABLE account as something that enhances the life of your loved one, but is not an estate plan. The supplemental needs trust is an estate plan tool. The Maryland ABLE is a tool to enhance the life of your loved one. So Jeff, I'm going to pretty much hand it over to you at this point and not go through the rest of these slides. There may be questions, and I hope we're on time to end by 11:30. And I thank everybody for your time and attention. And just know, we are here to help, we are here to educate, and we're here to give you a path forward. And Jeff, I'll turn it over to you.
Well, thanks as always, Steve. And we do have a few questions to wrap up, and then I'll have some closing thoughts and comments. So the first question is, would you recommend an independent trust protector and not a family member?
Excellent question. The answer is absolutely yes, because you've hit on something very important, and that is that a trust protector really can't be a family member. Now, there are times when families will say, well, I really don't want anyone else but a family member. But a trust protector by its very nature should be someone who is independent and arm's length from the family, because we don't want any conflicts of interest. That's a wonderful question.
Next question, should financial advisors or lawyers be on the trust advisory committee?
Excellent, thank you so much. I think it's possible, yes. When we think of a trust advisory committee, we typically don't think of lawyers being on there, but yes, I think that the common sense might dictate that if there is a situation that was dire, and I've faced some of those situations myself as a trustee of a trust, there are exigent circumstances, or the beneficiary is at risk, or there's legal questions, absolutely. The trust advisory committee could include the lawyer who is the family special needs planner.
Next question is, in order to set up an ABLE account, you have to have a POA. Are there any options other than a POA to set up an ABLE account, especially for a kid who has potential to make their own decisions one day?
I think the answer to that, and I'll defer to Kelly Nelson of Maryland ABLE on that, I believe the answer is that your higher functioning child could appoint you as their legal representative as part of the establishment of the ABLE account. I hope I'm talking apples and apples to your question here. So I think as part of that process, it sounds like your child is more higher functioning and independent, and I think they can authorize you as their power of attorney, so to speak, for Maryland ABLE to establish that account. I believe that would be the answer, but Jeff can give you Kelly Nelson's information.
Steve, I believe you're exactly right. They have their own specific form as far as quote unquote a power of attorney would be concerned, that you can then fill out and send in through their online service to establish an account. And so you're exactly right on that. And it's included in the slides as well, and it will be explained in the ABLE video that I will include in my follow-up information. So thank you. Next question, there's a couple more. Is my daughter required to take out SSI or SSDI when she turns 18?
Thank you. The answer is no, there's no requirement. And there are families, not knowing the nature of your question, where it's coming from, there are families that say, well, you know, my daughter may not need SSI, or I don't want her to be on means tested public benefits. I don't want her to be, defined quintessentially as a disabled person. There may be many reasons why you don't want that. If you ultimately go or lean in the direction that she should have SSI, statistics show that even though it's not a large amount of money every month, that over time, the statistics show that financially, if her supplemental needs trust, let's say, does not have more than $3 million in it, meaning let's just say it has a lesser amount than $3 million, and I'm using very round numbers, that her receipt of SSI and medical assistance will show mathematically that that was very, very advantageous for her to have. But you may have reasons otherwise that you don't want her to be on SSI or in the waiver system and other things. But no, it is not required that you apply at age 18.
Okay, and for right now, those are all the questions that we have. And so if you do have a burning question at the last moment here, now would be your time, as I have some closing comments. So typically, as many of you know that are on the presentations, I send up what I'd like to always try to make a comprehensive email follow-up with some resources for you. So with this presentation, that always is a good bit of information. So I'm going to include, as we always do with this one, a copy of a memorandum of intent for you. Also, the list of things that a trust can pay for. Also, a link to our most recent Maryland ABLE presentation that we had as part of our Elville webinar series, which was back at the beginning of this year. And we are in the process of setting up another presentation with Kelly Nelson, the outreach coordinator with Maryland ABLE, for this summer. So be on the lookout for that. She is a wonderful resource. And in that email, I'll include her contact information. It is also knelson@marylandable.org. But again, I'll include that information in my email. I'll also include the video of today's presentation as well. And also just a little bit of information about a couple of presentations we have coming up for advisors on the presentation. We have our advisors forum about the Biden era tax law changes and for the 99.5% acts and much more. That's on May 12th. Also on Tuesday, May 18th, all about D4A special needs trusts. So that's a new presentation that we have coming up, and we're looking forward to that as well. And also on May 20th, estate planning for the surviving spouse, considerations, recommendations, and procedures. So those are the next few that we have coming up, and invitations are always coming out. You can find out more information on our events page on our website as well. And also just last thing about Maryland ABLE, since we've been talking about it, we're going to be blogging about that tomorrow. And not sure if you've heard about the ABLE Age Adjustment Act. I know that typically, and in the past, you've had the onset age of the disability be before age 26, and there was a bill that was introduced into Congress in March that is trying to raise that age finally after many attempts to age 46, I believe it is. So we're going to be blogging about that tomorrow, and we'll have that on our website, and I'll include the link to that in my follow-up message as well, so you can read about that. So that's exciting news that hopefully we'll get past this time. So I think that's everything, and we look forward to being a resource to you. Again, don't be shy. Consultations are free, and looking to give you a path forward in your planning and try to create some solutions for your family and your special needs loved one.
Jeff, will you be sending out a survey?
Yes, again, and please, as I mentioned at the beginning, fill out our post-webinar feedback survey. It just takes 2 minutes. We appreciate all your feedback and comments. And again, it's a nice time to, if you want to request a consultation with Steve, you can just simply click yes, and we can reach out to you to set a time to do that. And so that's the easiest way to do it. Or you can also email me at jeff@elvilleassociates.com, and I can arrange for that as well. So it looks like no more questions, Steve. I think we're finished up at 11:32. So appreciate everybody being here today and being part of our Elville webinar series as always, and we look forward to seeing you again soon. Thanks again.
Thank you, everyone.